The question of whether or not you have to pay your lawyer back expenses or fees when you lose the case, or if you lose the case, is governed by the agreement that you sign with the lawyer, and in some cases by state law. Most agreements that you sign or get from lawyers should state very clearly that if there is no recovery, you do not owe any fees or expenses. In other words, if you do not receive compensation, you should never be in the position of having to write your lawyer a check for fees or expenses. That's the basic agreement that all mesothelioma law firms use. There are a few states that require language in the agreement that holds the client potentially responsible for the expense part of the case, not the fees. But all the lawyers I know who do this would never collect those expenses from their client. So one of the first questions you want to ask is, what happens if I lose? Do I owe you anything? You want to make sure in the retainer agreement you sign, it is crystal clear that you don't owe anything if there's no recovery. You're never going to be in the position of writing your lawyer a check. And if there's an issue of state law that makes those terms slightly different, you want to have a real conversation with your potential lawyer about how that situation is going to be handled. The risk of taking on the lawsuit should be on the lawyer, not the client. We're the ones who spend the time and the expenses working on the case. And if we don't make the case happen, we're the ones who should be out that time and out those expenses, not the client.